My name is Bush Nielsen. This is the sixth and final video in a series that I've done having to do with closing protection letters and title agents who serve as the closing agents for lenders. In this video, I describe the options that are sometimes described as alternatives to closing protection letters. I want to discuss all those options and explain how they work and how they relate to the coverage of the closing protection letter. A number of these so-called alternatives have been discussed by the NAIC, or the National Association of Insurance Commissioners, in a white paper that they produced recently, and also in trade industry articles, including one that appeared in the ALTA Title News fairly recently. At the end of this video, there will be a slide that shows you how you can go to a frequently asked question sheet that I've prepared that will point you to the white paper prepared by the NAIC and to different articles produced by the industry about these alternatives to the closing protection letter. Let me give you a summary of the options. The first idea that people have floated regularly is that the closing protection letter, or at least the threat of serious loss under a closing protection letter, is either limited or eliminated by enough audits of title agents and controls on escrow accounts. Since 2013, many title agents have worked very, very hard to become compliant with the best practices that have been promulgated by the ALTA. And one of the pillars of the ALTA best practices is a whole series of controls on the agent's escrow account. Some people have suggested that once an agent is able to self-certify that it complies with all of the pillars of the ALTA best practices, that effectively makes the CPL irrelevant, or that no losses will ever be suffered under it. It's true that every control that is put on an escrow account limits the amount of money that can be stolen and the number of people who can steal money from an escrow account. However, the main effect of those best practices is simply to limit the number of people and the amount that can be stolen. Those best practices do not eliminate the possibility of theft, especially theft by a business owner. Now, there are companies that only issue fidelity bonds for employee theft. And I worked for a man for many years who had spent the first part of his career handling claims under employee theft bonds. He taught me this one principle that the title industry has come to learn is very true also. No amount of controls or audits can prevent a theft, but controls and audits limit the amount of the theft, limit the number of people who can steal, and also typically will allow the company to figure out more quickly that money has already been stolen. That's the whole effect of those controls. Audits by title insurers also have been, a number of people have said, actually should cause the title insurer never to suffer a loss under a closing protection letter. Some title agents have said to me, in fact, that if the title insurers were more careful about conducting audits of escrow accounts, they would never pay any of these CPL losses. Here's the bottom line about audits. Again, the audit can discover a theft that has already occurred, and it can limit the amount of money that is stolen, but it can never prevent theft from the escrow account. And it is not uncommon for the first theft from an escrow account to occur immediately after the audit by the title insurer, because that's when the agent realizes that he's in the clear for a while. Another common theme that I've heard from title agents is that CPL claims really exist because title insurers have agreed to sign agents who are just bad agents, people who haven't been in the business for very long, who don't know what they're doing, and who maybe didn't have very high moral standards when they were allowed to enter the business. This just is not true. I have dealt with a number of thefts from escrow accounts. Most of the cases in which I have dealt with those thefts, the person stealing the money has been highly respected in the industry, has been in the industry for a long time, and has had an excellent reputation, both with title insurers and with other title agents. And that's why in those cases, which have been very sad, everyone has been shocked to realize that this particular person has stolen money from the escrow account. So I just don't think that that is a valid criticism. Now, a number of people have also said that there must be, or maybe there should be, some other kind of insurance or bond that could replace the closing protection letter. This is a question that I've been asked by regulators. It would be nice if there was some other kind of insurance, I think. because then there would be other options. There would, of course, also be another premium to pay. But think carefully about what the closing protection letter does, which is different from most kinds of insurance. Most kinds of insurance say, we protect against this, that, and the other risk, but we will not protect against a criminal act, particularly theft. That exclusion appears in every agent E&O policy and all kinds of other insurance. The closing protection letter's main purpose is to protect against theft. So a criminal act, the thing that most insurance companies refuse to write insurance about, and some states have said is actually a moral hazard, the idea that you can get insurance against your own criminal acts. So no, there is no other kind of insurance that can be purchased that would replace the closing protection letter. Now, there are other products that are similar or that overlap with the closing protection letter. Secure Settlements, known as SSI, offers a policy that it issues to lenders, and that lenders purchase from SSI or from the insurance company that SSI partners with. That insurance policy specifically says that it does not cover risks that are already covered by closing protection letters. It says that that coverage is excess to a closing protection letter, or that the coverage under the SSI policy is excluded as to the extent that there is coverage under a closing protection letter. I give more information, by the way, about the SSI policy on a frequently asked questions sheet that appears on our firm website, and there will be a slide at the end of this presentation that shows you how to get to that frequently asked question sheet. Now, another idea that is frequently floated is the idea that there should be a guarantee fund set up by the state or possibly by a nonprofit organization that money would be paid into and from which claims would be paid to reimburse people for theft from an escrow account. The idea normally is that title agents would pay money into this guarantee fund, the money would build up over time, and then the trustees of the fund would pay out money to the people who have suffered the losses. The first issue about getting a guarantee fund is that the state has to set it up, and typically the state has to run it. Any system that requires a law or a regulation also requires the support of the regulator who's going to be in charge of that fund. Most regulators who I have talked to or that I'm aware of do not want any more of these guarantee funds. There are guarantee funds that have existed. The problem with them is that they haven't worked very well. They cost a lot of money to administer. They don't pay out claims very often. It takes forever for people to be paid claims from these guarantee funds. And then eventually the fund runs out of money and then it's kaput, and then no more claims are paid. And then the state catches bad publicity about it because there was a fund set up for a certain purpose and now people can't be paid because the fund has run dry. So the title industry cannot simply go to a state Department of Insurance and ask it to set up a fund. The Department of Insurance has to agree that a fund should be set up, and they're very reluctant to set up funds that require a lot of oversight and a lot of time to manage. Now, there is one state that has a guarantee fund. That state is Texas. And it is specifically an escrow theft title agent guarantee fund. Let me give you some of the information about it, but there's more information on the FAQ sheet that is on our firm website. The first thing to note about the Texas system is that the law does not say that the fund replaces closing protection letters. In fact, in Texas, the fund is statutory, but there's a different statute that says the title insurers must issue closing protection letters to all parties to a transaction. So they are not mutually exclusive. The Texas Guarantee Fund is called the Texas Title Insurance Guarantee Association. It's a nonprofit, unincorporated association. Here's how it works. Title agents pay fees directly to the association, a certain amount on every single policy that they issue. So all the money is paid by title agents. No money is paid by title insurers or customers in the transactions. The money is used to pay claims and to reimburse the insurance department for the escrow audits that it performs on title agents. Now, in 2014, ironically, the Texas Association collected a special additional charge so that it could pay claims out when Southern Title Insurance Company, an underwriter, failed. The problem with Southern was that both the underwriter and its Texas agents failed because of CPL claims that Southern paid. So ironically, the title agents in Texas paid into a fund in order to cover the risks that the insurer, Southern, had incurred on closing protection letters. So the fund actually covered the letters. There are some other things. Oh, by the way, some people have noted that the fund in Texas collected so much money on Southern Title in 2014 that it has suspended the requirement to pay money into the fund in 2015. This is true. This is a temporary one-year suspension because so much extra money was paid into the fund in 2014. Some people have inaccurately reported that the fund is so overfunded that no one has to pay into the fund anymore. It's a one-year suspension of payments. Now, a couple of things about this fund. The fund does not pay out unless the title agent goes bust. So if an employee steals money from the title agent and the agent covers that loss, it cannot make a claim against the fund. Also, the Texas fund is just one part of the regulation of the escrow and closing business by the Texas Department of Insurance. And this makes sense because no state is willing to set up a guarantee fund that covers a risk without having other controls in place to protect against the eventuality of that risk. So here are the other things that Texas has set up. As I said before, the Texas Department of Insurance conducts escrow audits of every title agent in the state every year, and the cost of those audits by the state employees is paid for by the title agents through the money that they pay into the Texas fund. Also, the Texas law requires title agents to put all of their closing money into escrow accounts that are actually managed and set up by title insurance companies. This means that in Texas, a title agent does not decide which bank it's going to put its escrow money into. It also does not receive the benefits that accrue in that escrow account. The title insurer sets up the bank account, it monitors the account intensively, and if there are benefits, and there are, in those accounts that are paid by the banks, those benefits are paid to the title insurers, not the agents. Also, after the Texas Department audits the agents every year, it also requires the agent to maintain a minimal capitalization in that state, which is not insubstantial. And the agent must certify each year to the auditor that it still has the minimum capitalization for a title agent. Also, the title agent must buy a different bond in favor of the state to cover the state's expense that it might incur on losses from the title agent. Also, there are other regulations of all the escrow and closing procedures that are performed by title agents in the state of Texas, because Texas intensively regulates the business of escrow and closings. By contrast, Midwestern states such as Michigan do not regulate the subject of escrow and closings at all. The insurance department doesn't regulate that subject, nor does any other department of the state. Another issue that people bring up regularly is that some states have adopted strict liability laws, and some people believe that if a state has a strict liability law, that should replace the closing protection letter. There are 3 states that have strict liability. The idea is that the law simply says that if there is a theft by a title agent from its escrow account, the title insurer must pay back everyone whose money has been stolen. The 3 states are Florida, Nebraska, and Utah. As I said, some people assume that these laws take the place of closing protection letters. In fact, they do not. Lenders insist on receiving closing protection letters in all 3 of those states, notwithstanding the strict liability laws. And in fact, in both Utah and Florida, there are laws that mandate the issuance of closing protection letters in addition to the strict liability statutes. So this is not an either-or situation. Another reason that the closing protection letter and the strict liability law are not the same subject is that the closing protection letter, remember, has 2 coverages in it. One is about the theft of money. The other is about the title agent's failure to follow written instructions that are given to it by the by the lender. That second coverage about the failure to follow written instructions can, in some cases, be the most significant coverage and can cause payment of millions of dollars, even when the title agent has not stolen any money. Okay, the final idea that people have floated that would replace the closing protection letter actually does replace the need for a closing protection letter. It's often called centralized loan disbursement. Interestingly, this is the only option that people have discussed or that anyone has come up with yet that doesn't require any law at all. It also is the only option that a title insurer would be able to implement today in any state in which it does business, because the system already exists. Title insurers already do centralized disbursement in all of the what are called the true escrow states, the western states, which are California, Washington, Oregon, Arizona, Utah, Nevada, and New Mexico. In those western states, centralized disbursement is referred to as sub-escrow. Sub-escrow came about this way. In California, traditionally, there were independent escrow companies that handled both documents and money in closings. They then sent the documents in for recording and then dispersed the money as was required on the HUD-1s. And then title insurers issued policies without having conducted the closings. Well, there are some very celebrated cases in which the owners of these independent escrow companies stole money from their escrow accounts. By the way, the articles about those cases are found on the frequently asked question sheet that's on our website, and that is listed in the slide that will appear at the end of this presentation. So, after those very large thefts by these independent escrow companies, the title insurers decided that they would handle the money from those closings conducted by independent escrow companies. So the way it works with sub-escrow is that the money is sent to a title insurer and dispersed by the title insurer based on the payoff letters that it receives from lenders and the other instructions that it receives from closing. The independent escrow company or the title agent handles the documents and performs the closing with the people present at the table or through a true escrow system. The title insurer can begin dispersing on behalf of a national lender in any state at any time. As I said, no regulator approval is required for this, particularly in a state that has no regulation of the escrow and closing system. Also, when a title insurer performs sub-escrows, it receives a fee for the sub-escrow service. Based on my experience with this in these other states, the title insurer breaks even on the expenses that it incurs in handling the money versus the fees that it is able to charge for that service. But it gets these two huge benefits in addition to that. It controls the money, preventing a title agent from stealing it. Also, it controls the money in order to make accurate payoffs of mortgage loans. And that is probably the largest source of title insurance claims in about half of the given years that you might study. The improper disbursement of loan money on the payoff of mortgage loans. So even if the title insurer received no money for sub-escrows, it would be way ahead in terms of its risk. But as I said, it's a break-even as a proposition, a business proposition, and then the insurer saves itself the millions of dollars of expense. In Michigan and other states, as I said, this could be implemented at any time. Let me just put this back to title agents who might be watching this video. If it is difficult for a title insurer to get a law adopted that will permit it to charge money for a closing protection letter, the easiest thing the title insurer can do in place of that is to conduct centralized disbursement or sub-escrow. This is the last video in this series. I hope you have found the videos to be helpful. I'd be delighted to take questions from you, answer emails. You'll find my email address on the slide that appears at the end of this video. I'd very much like it if you would watch all the videos in this series and read the frequently asked questions sheet that appears on our website. Thank you.